acre of timber. If he wished to plant potatoes or wheat, he put the flames through the undergrowth, felled the large trees, and dragged them aside to rot. The destruction was appalling, and it went on for 30 years without the slightest check or protest. But what's most important with this mission is that the Crown sponsored mass deforestation as well. It facilitated the taking out of the bush. Why? Because it wanted the settler economy to thrive. And the claimants are not averse to economic development. But what they are averse to is when that development is as expensive as it has been, with knowledge that you undertake this kind of activity with that much vigour and you're going to get a mess. So the Crown was pivotal to the process of destroying the bush. The Crown, according to Dr. Kent, appointed rangers to monitor and report on progress of settlers who took up Crown land by way of lease. The monitoring was to ensure that the farmers were in occupation and that the forests were cleared. The improvements were put in place, the pastures were seeded, the farms stocked. Schofield highlights the Crown leases and their facilitative, that outcome in relation to large-scale bush clearance. And I quote, "Even the settler became, by the terms of his lease, a wanton and a profligate. Under the strange definition of improvements, he was compelled to hack down a certain area of bush each year. Whether he could convert the timber was immaterial. If there was no sawmill at hand, he had simply to destroy it and sow grass and graze sheep among the blackened logs." Through its land purchasing program, the Crown became the owner of large tracts of land that were covered in dense, thick bush. The Crown entered into leases with settlers to clear that bush, and in this way the Crown sponsored mass deforestation. The Crown facilitated large-scale bush clearance through these leases with these kinds of conditions, but also through keeping the price of timber down, through making timber leases not as expensive as they should have been. And when they're cheap, they'll get purchased and the bush will get felled. A simple formula. In this respect, it's Schofield again who comments, and I quote, "While the whole 150 mills were busy at this work, milling timber, the colonial exchequer received only a paltry £2,600 a year in revenue from the forests." So for the Crown, it wasn't a revenue profit-making exercise, it was get rid of the bush at all costs, at no cost. The Crown facilitated bush clearance through the Timber Floatage Act of 1873. During the argument, or the debate that ensued in Parliament, Karaitiana Takamoana, the member for Eastern Māori, stated as follows. He said this was a bill, the Timber Floatage of Timber Bill, that would have effect upon native land. Great trouble would come upon the Māoris if this bill was passed. Land would be washed away by the water and eel weirs destroyed. If these eel weirs were destroyed, no power on earth could repair them again. And this bill would cause great distress among the Māoris on this account. Petitions had been received from natives owning kauri trees, forests, must have been from up north, expressing their great distress at the destruction which would be caused to their land if this bill passed. So not only do we have opposition to the bill in relation to the destruction of eel weirs, but importantly, I'd like to highlight to the Tribunal, we have protests from Northland Māori in relation to the destruction of their forest, and this is 1873. That's evidence that Māori at the time were opposed to what was going on, but could do nothing, and are now left with the mess. The impacts of mass deforestation have been rampant soil erosion. Dr. Hearn talks about, and I quote, the rapid and extensive deforestation of the catchments of rivers draining into the Hokianga Harbour during the 19th and early 20th centuries was accompanied by accelerated erosion and the deposition of vast quantities of silt to form large areas of mudflats that I'm sure many of us would have seen. And so that's the result of mass deforestation, according to Dr. Hearn. And Dr. Kant, in his evidence, talks similarly about degradation of the environment as a result of large-scale bush clearance, where if the bush is replaced with grass, the surface soil becomes more compact, less rainfall is absorbed, there's increased runoff, wider fluctuations in the content of moisture in the soil. In dry periods the soil is more parched, and there's cracking of the ground. So there are the Hokianga mudflats, there are the drought-like conditions we often see here. It's Council's submission that as a result the Crown's greater interest in short-term profit than its better interest in long-term sustainability of its conduct and activities. Pond, in her Rangahaua Whānui report, lists a plethora of impacts of the environment on the environment as a result of deforestation. I won't go through those in the interest of time. I would like to turn to the relief sought, and specifically the claimants would want the present guardian of the environment, the Crown, and its various legislated for agencies to step aside. They've got it wrong and have had it wrong for too long an amount of time for it to be tolerated any longer. It is the claimants' recommendation that they would seek from this tribunal that the true kaitiaki be made the guardian of the environment, so that with their hearts and not with their dollar signs, they'll properly look after the environment going forward, because we will be here for a long time and so will the environment. And if nothing's done soon, something's going to give way. So in terms of specific recommendation, we would ask the tribunal to ask the Crown to step aside. Unless there are questions of a final submission in relation to education. Sir. The claimants allege in relation to this education claim that the treaty principles of...
Maiden,
Yes, sir.
are you going to cover the wards of the state matter?
Yes, sir. Mr. Lawless will be presenting on that, and I'm watching the clock very closely, sir. I think I've got 5 minutes on this education, and then it will be Mr. Lawless.
Okay,
So,
thank you.
the named claimant, Ms. Terenga Harris, was made a ward of the state, and as a result, her education experience was something of an outlier. She was placed in various social institutions as a young teenager, Allendale Girls' Home in Auckland there, and also Ferrum House Institutional Boarding School, which she likened to a jail. And so her education was highly practically oriented. And that's the subject of these education submissions. Specifically, it's about the emphasis on industrial training for Māori since the Education Ordinance of 1847. And it's Council's submission that there's evidence on the record that the emphasis by the Crown on practical education, on industrial training for Māori continues to this very day. It's Henry Taylor. He's an inspector of schools, and he's presenting a report on native schools to Parliament in 1862. And these are his words. And his words determine the curriculum for Māori for more than 100 years. He said, "I do not advocate for the natives under present circumstances a refined education or high mental culture. It would be inconsistent if we take into account the position they are likely to hold for many years to come in the social scale, and inappropriate if we remember that they are better calculated by nature to get their living by manual than by mental labour. So Henry Taylor, the Inspector of Schools, is setting the foundation for the way that the government would administer education to Māori Mairan. The Crown considered that Māori lacked the mental capacity to cope with the ordinary school curriculum, and so a separate school curriculum was created by way of the native land schools, by way of the native schools. The churches, with their mission schools, there's an emphasis on industrial training. The Native Schools Act of 1858, industrial training is a feature. The same with the 1867 Native Schools Act. Homemaking was important, sewing, agriculture, right up until the turn of the century and thereafter. James Pope was the inspector in native schools from 1879 on. He prepared the 1880 Native Schools Code. To him, manual education had equal importance with teaching English. Sir, at this point I'm going to just be prudent with my time and jump to some relief, that sort. Professor Wally Punetito has written recently that in his view, after years of academic research and study, for Māori to achieve equality, and I quote, there needs to be two recognised, officially mandated education systems, one that's Māori and one that's in Pākehā. In 2015 to 2016, we note that 13.2 billion was spent by the Crown on the delivery of education. We note too that Māori are 20% of the school's population. A recommendation is sought from this tribunal that 20% of the education budget be provided for a standalone Māori education system, approximately $2.6 billion. As opposed to building new Māori schools and wasting all their money on that, a recommendation is sought that existing schools be apportioned to Māori in accordance with the Māori attendance requirement of the area of the school services. Teachers would need to be Māori with a degree of fluency in Te Reo Māori, or not necessarily Māori, but with a degree of fluency in Te Reo Māori that would be above the pupils they are teaching. A recommendation is sought from this tribunal that colleges of education be required to allocate 20% of their buildings and resources to the training of Māori teachers for the above stated purpose. And a recommendation is sought for Crown funding to assist Māori educationalists, kaumātua kuia rangatahi, and others to design an appropriate curriculum for the standalone schools. And finally, a recommendation is sought that the curriculum be allowed to reflect the tikanga of the school and the teaching of Māori reo, tikanga, history, legends, waiata, technology, mathematics, science, medicine, astronomy, arts and crafts, waka building, house building and decoration, games and leisure activities within a Māori paradigm and within a Māori pedagogy. Your Honour, members of the panel, thank you for that opportunity. Those are council submissions. Unless there are questions, it will be Mr. Lawless, sir.
Thank you, Mr. Naden. Do you have a question? Let's hear about wards of the state.
If it please the tribunal, these are the submissions on wards of the state. I'd like to start with two quotes which, in my submission, illustrate the fundamental and the universal regard in which and value in which we hold our children. The first is from the 1924 Geneva Declaration on the Rights of the Child, and it's that mankind owes to the child the best it has to give. And the second is perhaps 2,000 years earlier, comes from Matthew 18:5-7. But whoso shall cause one of these little ones who believe in me to fall, it were better for him that a millstone were hung around his neck and he were cast into the sea and drowned. Sir, children are vulnerable, they're impressionable, and they represent our future. What could be more precious to any society than its children? What unit is more fundamental to any society than the family? The claimant's story, which they had the courage to tell here, is harrowing. Government departments separated their whānau. They created an environment in which they were physically, mentally and sexually abused. When they were released from the state system back into society, they were unable to function, mentally or socially. They themselves say that they're dysfunctional. They don't take any pride in that, they just say it because it's true. What they suffered at the hands of the Crown, the acts and omissions of the Crown, made them social pariahs, not only within society generally, but even within their own hapu. Now, if the government is going to arrogate to itself the role of a parent, it's axiomatic that the government must do at least as good a job of parenting as the child's natural parents. And it must at the minimum protect, feed, clothe, educate and prepare the child to take its place in a normal society. Now, any parent who allowed their child to be bullied, physically, mentally and sexually abused, locked them in cupboards, beat them, humiliated them, pushed them out the door at 17 with no skills, no education, no support, and equipped only to survive in a society where the strong prey on the weak, would generally be considered a bad parent. But that's what our government did to thousands of children. So I'm going to refer to some international covenants here. Before I do, I'll just refer that Sir Robin Cook, the President of the Court of Appeal in the New Zealand Maori Council, and the Attorney General, 1987 New Zealand Court of Appeal 60, said that the treaty should be interpreted widely and effectively as a living instrument, taking into account subsequent developments of international human rights norms, and the Y2417 Tribunal report on the Community Development Act claim endorsed that approach and said that in particular the UN DRIP informed the treaty principles with human rights norms now embedded in them. And in my submission, other international covenants are equally relevant. Okay. In particular, the Convention on the Rights of the Child, the Convention on Civil and Political Rights, the Convention on Torture and other cruel, inhuman or degrading treatment or punishment. Now, although those four instruments came into force after the events of which the claimants complain, the importance of family and children's long-standing and it's common to humanity as a whole. The duty to take particular care for children had already been specifically articulated in the 1924 Geneva Declaration, which eloquently stated, "The child that is hungry must be fed, the child that is sick must be nurtured, the child that is backward must be helped, the delinquent child must be reclaimed, and the orphan and the waif must be sheltered and succoured." 1959 UN Declaration provided in Principle 2, the child was to enjoy special protection, given opportunities and facilities to enable them to develop physically, mentally, morally, spiritually and socially in a healthy and normal manner and in conditions of freedom and dignity. Principle 6 said that the child, for his development, the development of his personality, needs love and understanding. He shall, wherever possible, grow up in the care and under the responsibility of his parents, and in any case, in an atmosphere of affection and moral and material security. A child of tender years shall not, save in exceptional circumstances, be separated from his mother. Principle 9, the child should be protected against all forms of neglect, cruelty and exploitation. Now, almost none of those principles were applied in favour of the claimants. And we will recall the claimants' evidence of being kept in solitary confinement, beaten, kept in their underwear to prevent them running away, tracked down with dogs. We have to ask, where was their freedom and dignity? When we recall their evidence of running away from the institutions to be with their parents and being dragged back and punished, we have to ask, were the circumstances so exceptional that they had to be permanently separated from their parents? Even if the decision to remove the children in the first place was justified, and the claimants don't accept that it was, when we hear of how they were treated in the state institutions, again we have to ask, How were they enabled to develop physically, mentally, morally, spiritually and socially in a healthy and normal manner? Now, whatever problems their parents may have been facing, at least the children felt loved in their family. Where was the love and understanding necessary to their development in the foster system and the state institutions? The plain fact is their development occurred in a manner and an environment that was anything but healthy and normal. It's no surprise that so many former inmates of these institutions graduated to prison or mental hospitals. About 40% of prison inmates grew up in the state system. Well, that's how they were brought up. It's what they were socialised into.
Just being aware of the time, do you want to conclude your submission on this matter?
Yes, sir.
And then we'll take questions.
All right, that's fine. Well, perhaps I can conclude with a question that the current Children's Commissioner, or the Children's Commissioner in 2005 observed. He said that he didn't know if children were any better off as a result of state intervention, but the indications weren't good. And certainly the Harris family weren't better off because of state intervention. Looking for relief, they're seeking redress for what they've suffered. They, put simply, the state broke their family and they want them to fix it. So they're seeking findings that the Crown failed to actively protect them, failed to actively rehabilitate them, failed to assist when it was apparent that they weren't coping, or that they hadn't successfully readjusted back. They want some recommendations that they be compensated, that the Crown facilitate any suitable resource of treatment or assistance to them and people like them, to properly and fully inquire into the historical abuse of state care, of children in state care, and that they examine the system as it pertains to children today, particularly to Maori children, to make sure it doesn't happen again. So, sir, I'm happy to take questions.
Tēnā koe. Do we know whether the situation's been improving for Māori in state care in terms of the numbers who are
No.
We don't
well,
know.
we do, yes. Yes, we know, and no, it's not getting any better. I have the latest report from the Children's Commissioner suggests that about 60 to 70%, I think 60% in care and 70% in youth justice Maori.
Yes. And I just looking at some of the legislative regime that has been in
Yes.
place over the past century.
Yes.
Strikes me it's more about control of children or control of families than care of families. Would you agree with that?
Yes, I would. It's a government knows best type of thing. Interestingly, going back to 1925 with the legislation then, there was provision for inspection. There was actually a duty on the Commissioner to go and inspect and interview inmates. There were penal provisions for ill-treating or neglecting children in state care, for having intercourse with female inmates. But those just seem to have been ignored. Nothing ever happened. So yes, I think it was about controlling. It was potentially even influenced by something like the eugenics movement.
And do you think that control goes beyond the child itself to
To the
wider
family.
society?
Yes, I think it does. It's what greater fear do any of us have that someone's going to come and take our children? So if we have that fear, we're going to comply. We're going to keep our heads down.
All right, thank you. It's very sad reading, I have to say. Thank you.
Kia ora, Mr. Lawless. I think you've referred to the establishment of the Confidential Listening and Advice Service in 2008.
Yes.
Which Judge Henwood presided over. How far did the establishment of that service meet the Crown's obligations in respect of considering the abuse to those wards of the state who had suffered it?
Not fully. I think the fact that there's recently been an application for an urgent inquiry into that system and the way the system worked and the adequacy of that system suggests that it's not enough for the people who were involved in that system. And all it really gave them, it had no teeth. It gave them a chance, a listening board, a chance perhaps to vent, to have their stories heard, but while there can be some catharsis in that, there needs to be some redress, some compensation, some making good.
So no compensation was paid through that process? Was that the...
I believe that to be the case, sir. I could be wrong, but I understand that it was simply a listening and advice service. There may have been some provision for compensation
Yeah, well, that probably goes to the question of subsequent Crown responses to that report.
Yes, yes.
Which involves, as I understand, dealing with particular individuals.
Yes.
And attempting to provide redress, but there's been no general apology to wards of the state, again, as I understand it, because the government considers the majority of children did not suffer abuse. That's the grounds on which that is stated. I think that also has been generally questioned as to whether that's an adequate public response to the whole system of wards of the state and the processes of it, and whether the public therefore remains in ignorance really of much of what happened.
Yes, I'd agree with that, and when we see the Human Rights Commissioner, the Children's Commissioner, the Race Relations Commissioner, the Mana Party, the Maori Party, all calling for a public inquiry, I think that momentum is building, and the government needs to listen to that.
Has the Crown got particular duties under Te Tiriti in respect of Māori wards of the state who have suffered abuse?
In my submission, yes, it comes within the duties of active protection and equity. I don't think it could possibly be an excuse to say that, well, we treated non-Māori children the same way. Do they owe greater duties to Māori children than to non-Māori children? Well, arguably yes, because of the special position of Māori generally as treaty partners.
I note that the recent tribunal report, To Mai Terangi, on Māori reoffending, has perhaps some relevant comments on Te Ira Tangata, the essence of life, as a taonga, and notes the claimant's comment in the particular circumstances of that claim that Māori people, families, and particularly their younger members who are at risk should be considered taonga.
Absolutely.
And so it's possible there's a parallel set of circumstances in this case.
Yes, I'd agree with that.
Thank you. Kia ora.
Thank you. Tēnā koe, and thank you for those submissions. Thank you, Mr. Naden.
Thank you,
We'll move to 3.3. Is it 256?
Yes, sir, that's correct. 256, and we have Ms. Roughton to present that
Thank
submission
you.
in its entirety.
Thank you, sir. May it please the Tribunal, today I'll be presenting the closing submissions of James Hanari Tutuhi. Mr Tutuhi is the named claimant for Y2061, and this claim is brought on behalf of himself, his whānau, and his hapus Te Popoto and Te Hikutu. I'll refer to Mr. Tatuhi as Jim throughout these submissions. I just want to note two introductory points. That the claimant's ancestral lands lie at Whirinaki in the Hokianga and are the central subject of these submissions. And under tikanga, the mana of his grandfather, Te Tu'i Heretini, passed over his father and rests with Jim. I will now set out the details of the whenua at Whirinaki. In 1885, the Whirinaki block was 2,360 acres and was investigated by Judge Paki at Waimati. Te Tu'i Heretini was not identified as an owner at that time. However, in 1894, he was awarded interest in Whirinaki 5 and Whirinaki 6. In 1904, the claimant's interest went into 5H, 5J, and 5T. 5H is the whānau's urupa and is also known as Pukekoko. 5J East is where the family homestead is located, where the whānau grew crops and lived. This is the land that was vested in the Māori trustee to pay rates arrears and was sold outside the whānau. 5J West is where the Methodist church is, which was gifted from the whānau to the Methodist church. And 5T is the land that Mr. Tutui's grandfather farmed. And this land was unilaterally Europeanised and has been lost. Whirinaki itself has been increasingly fragmented over the years, and by 1971 it had been cut up into 181 blocks. Today, just 67 of those blocks remain in Māori ownership. I want to move now just to speak to the first issue, that being of the Māori trustee. We adopt the submissions filed by Tukau Law, and I just want to set out three main points in relation to the Māori trustee. Firstly, that the claimants claim that the Crown failed to actively protect their tūranga waiwai from permanent alienation. In relation to this, the prejudice stemmed from deficient legislation and the powers that were given to the Māori trustee. There was also the issue of the Crown's failure to consult with affected owners, and also the Crown's failure to actively protect the claimant's best interest in that their right to manage their lands in accordance with their laws and their custom. I just want to mention a couple of previous tribunal findings. The Kahui Monga Tribunal held that legislation which enabled the Crown to acquire Māori land against the wishes of its owners was in breach of the principles of partnership and active protection. And the Tauranga Moana Tribunal found that the Māori trustee was a key agent in the alienation of Māori land, and any forced taking of land for rates debt was unjustifiable, particularly when Māori land holdings were so limited, and in failing to mitigate ratings pressures that contributed to non-compulsory or compulsory sales, the Crown breached its duty of active protection. In this inquiry, the Crown has not addressed the Māori trustee's power to sell lands without consultation or notification, or the Māori trustee's power to Europeanise land interests. I want to speak now to the deficient legislation. The claimants were disinherited of their whenua by the Māori Affairs Act of 1953. The Crown, in enacting this act, breached Te Tiriti duties, in particular of active protection and partnership. And in the claimant's own words, the application of this act resulted in a situation where the whānau now have no remaining land interests in Whirinaki, even though they have strong ancestral ties to the land, even though we have strong ancestral ties to the land. I want to look at 7 deficiencies in the Māori Affairs Act as they relate to the claimant's lands. The first is that the Act allowed any person or any entity to make an application to the Māori Land Court to consider whether a block of land should be vested. This gave a third party the opportunity to change the management or ownership of the land, and for the claimants, the offending third party was the Hokianga County Council. Secondly, the Act ought to have required the notification and consent of all owners by the Māori trustee, especially those in occupation. In the claimant's case, Jim's auntie, Nana Barlow, had an ownership interest, and yet the Māori trustee failed to consult with her, obtain her consent prior to confirming the alienation. She was one of 3 surviving successors and was occupying the land at the time of its alienation. Thirdly, the Māori trustee was not required to scrutinise all interested owners, but could rely exclusively on the consent of a sole applicant for succession and sale. Under Section 483, subsection 3 of the Act, the court was prohibited in making a vesting order if it felt that there was a meritorious objection from a beneficial owner, but without a requirement or a process to ensure that all beneficial owners were consulted and that any objections could be made, that protection is a nullity and is of no effect. Fourthly, there was no requirement to consider the landlessness or sufficiency of land of the owners prior to effecting the sale of the land. There was a limited protection that vesting was supposed to be done for the benefit of Māori or the benefits of the descendants of Māori. However, given the landlessness of the claimants, the vesting that took place was not in their best interests, in that it did not benefit them in the long term. Whatever benefit they received by way of any sale proceeds after the rates arrears were paid could never outweigh the spiritual significance of losing their tūranga waiwai, as well as their diminishing economic capability. The cost was greater to the claimants than any benefit that might be argued. Fifthly, there was no required under Section 135 of the Act to act in accordance with tikanga in relation to succession. Sixth, there was no requirement to take all measures possible to retain the land within the whānau. The Māori trustee had an opportunity by the highest bidder, who was a man called Mac Murunga, who was within the whānau. He asked the Māori trustee to give him the opportunity to go directly to whānau members and purchase their interests off them. The Māori trustee denied this request and ultimately sold it outside of the whānau. And lastly, there was no requirement under the Act that the Minister of Māori Affairs conduct an investigation into the vesting. Although under subsection 4, no vesting order shall take an effect until it was approved by the Minister, without an investigation into any prejudice that might be suffered under a vesting, that protection is also of no effect. It is our submission that the 1953 and the 1967 Amendment Act reflected the goals of the Crown and were geared towards the economic goals of land use transferability and tenure conversion. And those powers directly led to the disinheritance of the claimants and the loss of their lands at Whirinaki. In terms of consultation, there was a definite lack of consultation by the Crown in relation to the passing of those laws. Māori protested fiercely, but yet the Crown continued with their objective to push that legislation through. And secondly, in relation to the lands at Whirinaki, the Māori trustee followed the example of the Crown and did not consult with the claimants. The third part of this claim issue of the Māori trustee is that in establishing the Māori trustee, the Crown was obliged to ensure it carried out its roles in the best interests of the Māori landowners by considering their values and aspirations. In treaty terms, this means that the Crown needed to actively protect the interests of the claimants and their right to develop, their right to their tino rangatiratanga, and their right to control their whenua according to their own customs and law. The claimants aspired to keep their few remaining lands, to have their tikanga and mana whenua recognised, to administer and manage their lands as they see fit, and to retain their tonga, their tūranga waiwai. The Crown was made aware of the claimants' aspirations but did not protect them. I'd now like to speak to the next claim issue, which is that of tikanga. These submissions on tikanga rely and adopt the submissions filed by Wackrow Williams. It is the claimant's submission that the principles of the treaty require the Crown to actively protect the claimant's te reo tino rangatiratanga, which applies to all Māori interests, and thus the Crown was duty-bound to protect tikanga and the claimant's right to practice tikanga Māori. In abrogation of this duty, the Crown imposed a European law land tenure that did not operate according to tikanga or even acknowledge or recognise it at a minimum. Jim's grandfather was the sole owner of Whirinaki 5J, and under tikanga, ownership or mana whenua passed over his son, Urawera, to his grandson, to Jim. However, neither the County Council, the Māori Land Court, nor the Māori Trustee recognised nor took tikanga into account when they dealt with the claimants. They dealt with Jim's father, who they assumed to have the mana whenua. They put him under pressure to sell the land, and he sold it in breach of tikanga, but he could only do so because the Māori Affairs Act was defective and it did not take tikanga into account or acknowledge it. It follows that the Crown, in enacting that legislation and in creating the Māori Land Court process, did not give effect to tikanga and has breached its duties under Te Tiriti of active protection and the principle of autonomy. I'd now like to speak to the third issue of that, of rating and the devolution of responsibilities to local government. These submissions rely and adopt the submissions file base 1, legal, and in particular, we adopt the position that any rating of Māori land is inconsistent with Article 2 of Te Tiriti in that it unjustifiably disturbed Māori possession of their tonga tuku iho. Secondly, when delegating responsibilities to local government, the Crown was required to ensure that it passed on with that responsibility the obligation to uphold Te Tiriti, and any forced taking of land for rates debt was unjustifiable, particularly where Māori land holdings were already limited, and the Crown also had a duty to mitigate ratings pressures, and this was encompassed within the duty of active protection. We submit that the Crown, in this regard, failed the claimants. The claimant's claim is that in 1972, the Hokianga County Council had issued a notice setting out the outstanding rates. The claimant, Jim Tutui, was away overseas at the time, serving with the New Zealand Defence Force in Singapore. He sent a letter to the council advising them that he would pay those arrears upon his return a few months later in the December of 1972. It was later found that the council had lost all documentation in relation to the alleged non-payments of rates due to a fire that destroyed all their records. The claimants alleged that the alleged rates bill was due to administrative error by the council in attributing rates payments to Whirinaki 5J West instead of 5J East. Under the Māori Affairs Act, the Crown lodged an application to have the land vested so that they could get their payment for rates. The land was vested, and despite the attempts of Mr. Murunga to keep the land within the whānau, the Māori trustees sold the land and the rates were paid. A key issue here is the devolution of responsibilities to the local council and their ability to lodge an application with the Māori Land Court that impinged on the claimant's ownership rights and their tino rangatiratanga. Any devolution of Te Tiriti obligations to local councils, particularly that are consultation and engagement responsibilities, become incumbent on that council. In this case, the council was ineffective in discharging the protective duties of the Crown by failing to mitigate the rates pressure, which led to the sale of Whirinaki 5J against the wishes and without the knowledge of all the owners. Jim had advised the council that he would pay their arrears, yet despite this, the council carried on with their goal to obtain the rates payment in the way that they saw fit, irrespective of the way that it would affect and prejudice the claimants. We acknowledge that the claimant's father did consent to the sale of Whirinaki 5J. However, he was under duress, and that duress was unreasonable given that payment had already been promised. But notwithstanding these facts, the Crown did nothing to mitigate the rates pressure imposed on the claimants. The Crown took no action to ensure that the local council consulted with all the beneficial owners prior to the sale of the land, and the Crown, by way of the Māori trustee, breached its te tiriti duties in facilitating the alienation of land without directly communicating with and consulting with all of the owners. I now want to speak to the last claim issue, which is the issue of economic development and capability. We adopt the submissions filed by Rainey Collins in respect of Tribunal issue 12, insofar as they support the economic development claims made by the claimants. However, these submissions will focus on one key point of distinction and also on the impact of the loss of lands, that the impact of the loss of lands had on the claimants in terms of their economic capability. Initially, I'd like to refer to some important findings of previous tribunals. The Whanganui Tribunal found that the Crown had an obligation to ensure that Māori retained sufficient lands. It breached its duty of active protection where it engaged in conduct that was unfair, exploitative, or which resulted in Māori selling land it could ill afford to lose. Also, that the Crown needed to err on the side of caution, making sure that Māori continued to own more rather than less land. The Tauranga Tribunal found that Māori have the right to a sufficient land and resource base to develop, and the right when and how to do so, to determine their own interests. In the generic closing submissions on economic development, Rainey Collins stated that the Tiraki region experienced an economic downturn prior to and in the 30 years after 1840. We would contend that the Tiraki Māori economic activity was not stagnant prior to 1840. At 1840, Tiraki Māori had a healthy and growing trade economy which had been growing since the late 18th century. Our submissions rely primarily on the substantial academic evidence provided by Dr. Manuka Hanari, where he has adduced that the Māori economy before 1840 was dynamic and fully developed. The salient point is that Māori who were involved in the trade economy continued to grow and develop until their loss of lands undermined their economic ability. By way of evidence, we would argue that the economic capability and development of Te Raki Māori was trending upwards at 1840. In relation to the evidence in support of this trade economy prior to 1840, I just want to comment on a few main points. Dr. Hanari gave evidence that according to Anne Salmon in 1769, the people of the Bay of Islands were numerous and wealthy, as indicated by the number and size of their settlements, their fleets of large carved canoes, their fine cloaks of dogskin, their prestige weapons, elaborate tattoos and huge nets. These were the observations of the crew of the Endeavour at the time, and they were only a snapshot of the actual strength of the economy. Dr. Hanari gave further evidence that from 1780, many eminent rangatira, including Te Pahi, Ruatara, Hongihika and Korokoro, went to Parramatta and spent many months living with Samuel Marsden. This is evidence of the fact that there were long-standing, there were trade relationships long established in Australia at a minimum. Mr. Tituhi has given evidence in his brief of evidence that one of his tupuna, Aparahama Tainui, was an interpreter on board the Sir George Murray. This was a trade ship, and this and its first mission was in 1830. Also, Dr. Hanari has given evidence that in 1819, Marsden commented on the richness of the Taiamai region. Also, Dr. O'Malley has agreed that at 1820, Te Raki Māori were trading pigs, potatoes and maize. There has been further evidence in this inquiry about the state of the Māori economy prior to 1840. The point of this evidence is to show that and it doesn't really do anything to negate the actions of the Crown post-1840, but to show that the prejudice to Māori of the diminishment of their economic capability and their ability to enter into the economic development within Aotearoa was that much more severe. I lastly just want to speak briefly to the issue of the economic capability of the claimants. On page 114 of our submission, we look at this issue. Rainey Collins, in their submission, set out the requisite elements of economic capability, the first of which is sufficient lands of a good quality. Our submission is that the claimants had the economic capability taken from them by the removal of that first constituent element, sufficient lands of a good quality. This happened by way of the alienation of Whirinaki 5J East in relation to the rates arrears, and also the Europeanisation of 5T, which was the land that Mr. Tutui's grandfather farmed. Importantly, the Crown did not ensure that the claimants had sufficiency of land when it alienated those lands. In terms of the prejudice felt by the claimants, as the prejudice has been outlined throughout the submission, I'd like just to move to the relief and just to a couple of specific points. The claimants are seeking many things, but I want to just specifically look at, they're seeking a recommendation that the Crown provides financial assistance to allow them to regain their economic capability. And in this respect, the financial assistance would allow them to either repurchase the lands that were lost at Whirinaki and to develop them as they see fit, or to invest in a commercial enterprise that would create economic capability and provide a firm financial future for their whānau and for future generations. A last recommendation that they would seek is that the Crown provides training and education opportunities to enable their whānau, their hapu, to be trained in business development, agribusiness, farming and other commercial opportunities for the same purpose of ensuring and improving their economic capability. Your Honour, those are claimants.
What's the Crown Forest land in the claimant's rohe?
I'm sorry, sir.
E, relief E. E, Roman numeral 2, Crown Forest land. At E, a recommendation that the Crown returns all land it currently owns within the claimant's traditional rohe includes, and it's got the Crown Forest land. Which
Sir,
Crown
I
Forest?
think that, I'm sorry, sir, that was a mistake to include that in there.
Thank you.
Thank you.
Anne, Robin? Dr. Parsonson has a question.
Kia ora.
You make an interesting point in respect of the 53 Act and the fact that there was no requirement to consider remaining lands of Māori when alienation was contemplated. And as we know, those requirements had been increasingly watered down in the past to the point where they didn't seem to exist anymore. As it seems that ultimately in this particular period there was no concern on the part of the Crown to ensure that whānau on the ground could retain small areas of land, of ancestral land perhaps, even though Crown officials often made statements about the importance of land to Māori and might well point to the policies of this period about the development of rural land as being designed to ensure that Māori did retain land. But that, of course, seems not to have met the needs of whānau for support from the Crown to ensure that their own remaining lands, which were so small, might be retained.
Yeah.
Is that a fair statement?
Yes, I think so.
And then we can think as well of the Hun report in 1960, in which it was suggested that so many Māori were moving into the cities that they really didn't need tūranga waiwai at home in their ancestral areas at all, but tūranga waiwai might be a section that they bought in town. So there was recognition of the importance of tūranga waiwai, but a reinterpretation of it. And perhaps that seems consistent with the developing Crown policy of these years.
Yeah, and I think it also points to the fact that the Crown like to kind of impose its view on where tūranga waiwai should be and what that should look like for Māori, instead of protecting their ability to, their autonomy and their ability to stay where they wanted to stay and do what they wanted to do with their own land.
Kia ora. Thank you.
Kia ora.
Tēnā koe. I'm interested in the aspect of this about the court failing to follow tikanga and recognise informal arrangements. Now, in this case, were they in a position really to do anything other than they did? Did they have the necessary information and discretion to award succession order to Mr. Tuhi rather than to his father?
We would kind of, I think at the position where the court was at, the answer would be no, but we would bring it right back to the actual setting up of the legislation, of the fact that tikanga was not taken into account in terms of succession, and there was no kind of premise within the Māori Land Court at that time to investigate or to consult or to find out. So the court, in terms of the issue with Whirinaki, they didn't have that information, but that was due to the underpinning process, the underpinning structure.
And putting aside whether the Native Land Court should have been set up in the first place or whether Māori should have been making these decisions themselves, is the problem with succession the law, or is it the case law? I mean, the statutory law, or is it the case law that's developed since Papakura decision? Do you have on succession?
We would go back to the legislation.
And the setting up of the court in the first place. All right, thank you.
Thank you.
Mr. Naden, did you have anything to add to that response? I just see you contemplating a response to it.
Yes, I was, because, we have submitted on this in relation to succession and the Papakura decision, Dr. Anderson in particular, and the option that was there for the court to refute the application of tikanga. And so the court had the option and took it. And what we would have preferred, what was necessary, was that there be no option for the court to apply the rules of intestacy as they did, so that in the end we've ended up with extreme fragmentation and the mess of management that prevails at this stage. There was an opportunity to avoid that, and the Crown provided that opportunity in the relevant legislation. And so Judge Fenton was able to take the option of applying the English law of succession because the legislation allowed him to. And that would be Council's submission. Thank you, sir.
Thank you, Mr. Naden.
Sir.
And thank you, Ms. Rawton.
Thank you, Steph. So we now have, in relation to the presentation of the Y 2005 claims, document 3.3.264, Mr. Kett, and he will talk to the customary spirituality closing submission.
Thank you.
Mai maketu ki Tongariro, ko te aroa te waka, ko Ngāti Wāhiao, me Ngāti Tuwharetō, ngā iwi, ko Tauhara te maunga, ko Ngāti Rauhoto te hapu, ko Stuart James Kett taku ingoa. May it please the Tribunal, the claimant Miss Denise Egan, on behalf of her whānau, Te Mahurihuri, give thanks to the panel for consideration of their claim. The wairua of the claimants is a very important element of the spirituality for them. They're also practicing Christians, and this is also a very important part of their spiritual worldview. Because of Crown actions in diminishing the wairua of Te Raki Māori and the claimants, through legislation, policy underpinned by Western and Christian doctrines, Crown-driven emphasis and prioritisation of these values, combined with the implicit and express undermining of Māori customary spirituality, the claimant has not had the same recognition of her Māori spiritual side as she has had of her Christian spiritual side. Again, generally the wairua of Māori and Te Raki Māori and the claimants has been diminished by the actions of the Crown. This speaks to Article 4 of Te Tiriti, relating to the freedom to practice religious viewpoints. This has been breached by the Crown, as has a general active protection duty. I'll traverse several examples of the entities that have been affected by this. Rangatira and Tōhunga are inherently spiritual actors, been undermined by policy and legislation. Concepts such as tapu have been undermined through education that promoted a Western and Christian ideal and viewpoint. There's been an express emphasis by Crown actors on Western Christian views over Māori customary spirituality ideals. This is actually reflected, I think a very pertinent example is the statement of George Clark, the native minister, in an address to the Bay of Islands District Runanga. This is from 1862 AJHR. And if I can quote, you are quite sensible of the errors of some of your Māori usages. One thing which has weakened or disheartened you in your labours was the thought that if you possess property, some excuse would be found by others whereby you would be robbed of all your gains. It is on account of this practice that the Māori cannot equal the Englishman, for he possesses no law which can act as a guardian to his property. This is the reason why this assembly is called together by the Governor and set up to be a runanga, in order to lay down good laws. Friends, let us labour as one with the government in this good work. Let all our thoughts pull one way, and thus throw all our strength together. May all our deliberations be guided and directed by the God of all wisdom, without whom nothing is strong, nothing is holy. May he lead us and teach us that we may do that which is pleasing in his sight. This kind of statement is indicative of the emphasis whereby Judeo-Christian worldviews, all the way through to really post-Enlightenment rationalist ethics and objectivity, how these things actually underpin any future prosperity, legislation. The doctrines being promoted are that leave your Māori ways behind, jump on our ship, and everything's going to be all good. It's a very striking passage in its open recognition of the cultural and spiritual hegemony being propagated by the Crown. And as I said, striking in the way in which this hegemony necessarily goes hand in hand with the denigration of Māori values. Moving on, the mana of mini wahine has been undermined through legislation and policy, affecting mana, affecting spiritual potential, and thus affecting wairua. Patriarchal Western Christian norms and legislation diminish the status of wahine Māori. From an education point of view, and Mr. Barrington in his A2 report outlines the denominational system as being predicated upon a training in divine truth, emphasise the word truth at the expense of particular Māori truths and customs. Tōhunga were undermined through education. The Suppression Act of 1907 distributed to native school teachers in 1909. Mr. Barrington, at page 59 of his report, traverses a rather telling exchange between the Secretary of Education and a native school teacher, in which they concoct a way to deal with students who wish to leave the school for a day to attend a tangi. Tōhunga is also mentioned here, and the way that teachers should deal with and dispose of the values and views that Tōhunga were propagating at the time amongst Māori. Dr. Henare, in his A16 report, has a very striking spiritual interpretation of the Treaty of Waitangi. In fact, he described the Treaty of Waitangi in post-hearing week 17 questions. He described the treaty as a taonga tapu. Rangatira marks on the treaty or recognition of the Crown in the person of the monarch as both a spiritual and temporal actor. Subsequent breaches of the treaty by the Crown have attenuated the tapu attached to the treaty, trampled the mana of signatories and their descendants. Diminution around tino rangatiratanga, of course, harmed the spiritual componentry inherent in that concept. The named claimant, Ms. Egan, in her Q9 brief of evidence, also notes the general social views that had flowed into Māori, that had been emphasised by the Crown through legislation and policy and action, specifically in regard to idolatry. In her marae, carvings and popo were taken down, and in her words, the marae was stripped bare. Just in light of these submissions, and if Your Honour doesn't mind, I'll just grab a tissue. Thank you, sir. So I just want to traverse some legislation that speaks to the submissions that I've just given there. I think it's an important point to emphasise, and Dr. Hanari does so. Wairua and mana are the very heart, soul and authority of Māori society. It's in his A37 report. There's an intrinsic link between the two concepts. If mana is harmed, wairua is harmed. In relation to rangatira, also in the A37 report, Dr. Hanare talks of the delegated authority from the spiritual plane that was imbued within rangatira in their person. So legislation that undercut mana also undercut wairua. The Lands Act of 65 and 73 undermined rangatira authority in mana by allowing individuals to apply to the court for adjudication on land without necessary consultation for hapu and tribal groups. This is predicated on a philosophy of individualism. Land is becoming a commodity. There's a rational post-enlightenment viewpoint that underpins this. Rangatira were denied their traditional role to adjudicate land-related matters. Their authority on decisions in regards to land allocation were undercut. Again, their mana and authority were rendered nugatory. Several claimants give evidence about the effects of land legislation on rangatira. Mr. Reihana in his 1957 brief of evidence talks of the undercutting of hapu structures and rangatira authority that came with the fragmentation of lands. Ms. Egan herself, at paragraph 51 of her brief, talks about the tapu and mana of leadership being undermined, affecting the wairua of the wider hapu. In a wahine context, and again, the mana being affected here by Crown legislation and policy, we note that whakapapa is where authority is derived from. This wasn't a strictly male domain. The early stages of the colonial project and before that and beyond, wahine could hold leadership roles, spiritual leadership roles within their groups. At the time, at the colonial time, this was arguably more opportunity, more ability to lead than their Western sisters coming over from Great Britain. In the A37 report, Dr. Henare notes the wahine signatories of the treaty. Female spiritual leaders had many roles many different categories. Their mana was trampled by things like the New Zealand Constitution Act 52, where voting was restricted to certain Pākehā and Māori males. Any decision-making authority that wahine had in a political sense within their own groups were undermined in the context of the politics coming into Aotearoa from Great Britain and the Crown. This was reflected again in the Māori Representation Act of 67. Māori was defined as a Māori or half-caste male. In section 3, if I'm not wrong, men could stand for representation in a parliament under section 2. Succession along bilateral lines was not uncommon for Te Raki Māori. The testamentary legislation that came in through section 86 of the Native Lands Act 73 required that husbands be a party to all deed. Further testamentary laws of Britain, as mentioned in the A37 report, also came in, meaning that the traditional ways of passing land on wasn't restricted to gender and these kind of things. The testamentary laws that came in undercut this status. Also, the kaitiaki status of many wahine, who were early cultivators of tribal land, as Dr. Henare puts it, was undermined by the Crown purchasing regime. Again, this affects the wairua of the wahine and the mana. It's further erosion of Māori wairua and customary spirituality. Within education, as I've touched on, the denominational system instituted originally by the Ordinance of 1847 by Governor Grey required religious instruction and instruction in the English language. The Native Schools Act 1858 at section 9 required English instruction. At section 10 required schools to gain funding to be connected with a religious body. Again, no mention in these legislative enactments of Māori spirituality, of Māori worldview. The Tohunga Suppression Act of 1907, described by the Y262 Tribunal as the subordination of one founding system and the prominence of the dominance of another. Tohunga were stigmatised, Tohunga were pushed to the side. The results and extent of the damage are almost beyond quantification. And just briefly, the purported usurpation of sovereignty also demoralised and contracted wairua. Now, I've been talking a lot about wairua and mana, so I do want to touch on, for want of a better term, a pre-contact form of the Māori religion, the traditions. Dr. Henare talks about an interconnectedness between the spiritual, physical, metaphysical planes. He talks of everything flowing from io. Now, this io tradition, in Henare's view, predates the onset of Christianity. This is the view of Henare. He did a lot of qualitative research. This is outlined in his A16 report. There are mentions in many waiata from around the country, Kōrero.
Well, because there's some argument that it's post-Christianity, isn't it?
There is an argument that it's a post-Christianity concept.
In his brief, he addresses those arguments and concludes that it is pre.
Dr. Henare does conclude it's predates Christianity. He goes so far as to say it was a normative concept at that time. He quotes Apirana Ngāta, who talks of it evolving here. Where it interplays with Christianity and Dr. Henare's viewpoint and in our submission is that Christianity as a monotheistic religion gave an intellectual vessel for the propagation of the io tradition, which was maybe a slightly more esoteric version of area of knowledge within Māori society. Christianity comes in, there's an easier way to explain the central sort of governing force, and so the intellectual concepts in Christianity were a helpful way to propagate the io tradition. So he sees it more as a propagating post-contact as opposed to an establishment post-contact. In terms of rangatira spirituality, I've touched on how that was suppressed. And in the A37 report, they quote Māori Marsden as in regards to the delegated mana for rangatira. An interesting alignment there with Western concepts of monarchy and the time and the appointment by God of, for example, institutions such as the Pope. There's another worldly power about many rangatira. For example, Turikatuku, Hongi Hika's wife, with matakite powers.